sure you'll come back and tell us new things.
All right, that was item 11B. Our next item on our agenda is item 13A. This is a consideration of request from Councilmember Denny regarding the currently ongoing code enforcement matter for the City of Coronado versus Lori St. Germain, San Diego Superior Court case number 37-2008-0008447 CUMC CTL. Direct city staff to request a refund of a reasonable amount of the $120,201.72 of public tax dollars paid over 13 years from May 8, 1998 to May 24, 2011, as per the professional service bills requested from McDougal, Love, Eckis, Boehmer, and Foley, our city's contract attorney firm. This requested fund of public tax dollars includes, but is not limited to, the more than 2-year time period from the date that plaintiff, City of Coronado, won a default judgment against defendant St. Germain in June of 2009 to today's date in this open case. First, I want to let our city attorney.
Mayor, although I can guarantee that I can give the city fair and impartial legal opinion on this matter, because of the potential financial impact to my employer, I will have to leave the dais.
All right. So our city attorney is going to step down as this matter might affect their finances. Ms. Downey, you have a point of order.
I have a point of order. You've read the title, and I'm perfectly capable of us discussing it under the title alone, but that's not what came before us. What came before us was a packet of information that, in my opinion, was protected by attorney-client privilege and shouldn't have been included. By putting it out in the public realm, which it certainly can't be more public than being attached to the City Council agenda, we run the risk of, actually we've already waived attorney-client privilege for that information. I realize it's, the horses have left the barn.
Are you referring to page 401 through?
Yes, I am.
The remainder of our agenda packet?
I am, and the reason it's a point of order is we started a ability in the city, which I think is a wonderful one, to let city council people request to put things on agenda, and we've kept talking about how muddled it is when they have to put it on to request, and then we have to at a later meeting bring it back to discuss. And this is a prime example of why we shouldn't have done it quite that way. We should have let one person raise the issue without all the backup data, so that if there isn't a vote to put it on, we don't get into all the backup data. I'm not getting into the merits of what was put on there. That we can talk about that if we proceed. But I'm talking about the ability to put information on the agenda without it being reviewed by an independent attorney, without it being reviewed by anybody. It's going to open us up, in my opinion, in this case, to doing something legally the city would not have chosen to do. No individual council member can waive attorney-client privilege. Only the client itself, which would be the city, could do that. And so what I think we've done is created a situation where that's what's happened, and I understand there didn't appear to be any reason. Let me rephrase that. I don't know that anybody would have realized that's what we'd created when we started it by putting that information into the packet. So my request is for a point of order. At this point, if we choose to deliberate on this and discuss whether we're going to bring it back at a later date.
I have to interrupt you and say, a point of order, you have to be challenging the right of the person to have the floor. So what is your point of order? That
this is not a legal matter to be brought up in this way. So therefore, we can't open up the floor to discussion. This matter needs
because it's waived attorney-client privilege?
Yes, and the people didn't have the authority to do that. Because this is an ongoing case. This case has not been resolved. So any discussion of it in an open forum, every time we discuss anything about it, is opening us up to waiving attorney-client privilege.
But your own admission is we've already waived it because...
For the information that's in there. Anything else we talk about is additional information that may come out, and I don't know what we'll talk about. Whatever winds up happening, the merits of whether this was legitimate bills or not.
Now, this puts me in a difficult position because the person I would usually ask
just left the room,
is
which is my
here.
problem.
Except you're not, and I could respond.
I haven't given you the floor yet, though. I know you're picky about that. I'm going to reject that argument. I think, unfortunately, if you're right, it's already happened. So our current policy allows council members to make requests. It's on our agenda. I think that's something we need to take up at a future date. Do we want to preempt the ability of one council member waiving confidential or legal, the confidentiality of our legal advice. In this case, you're saying one person's request has acted on all of our behalf. So I agree with you that that's an issue, but I also think that it's already been done then. This request has already done that. I think we're just going to have to hear a little before that decision's made.
Can you then limit the discussion? One person obviously is going to have the floor to discuss it, and then the rest of us can choose at that point to make a motion and vote and stop conversation.
Yes.
Okay. All right.
Ms. Denny.
I want to address the statements by both yourself and Mrs. Downey to say that you could not be more wrong. The matter was already passed through an independent third-party attorney, and I already dealt with staff and was made I was very, 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 very concerned about confidentiality and privilege, attorney-client privilege. And so I would have to say that the comments just made are nothing more than grandstanding, and I'm sorry that the public had to hear that. There's absolutely nothing wrong whatsoever with my agenda item. It's already been decided by a third-party independent attorney when the city attorney had difficulty.
I'm going to take the floor back and ask Mr. King, has a third-party attorney been contacted, and what was what determination was made, if any, by that third-party attorney? Mr. King.
Councilwoman Denny contacted me with the title that is on the agenda and with attachments. The attachments included the information present plus an email string. I contacted Mr. Jonathan Hobbs, who's an attorney with the firm of Chronic, Moscovitz, Tiedemann, Gerard. He practices municipal law in the Sacramento area. Based upon Mr. Hobbs' review, and we sent him the information, he gave me verbal advice that he felt that the email string was attorney-client privileged. We removed that and attached the piece. However, we did not ask the question, for example, whether this item could be discussed because it had been the topic of a closed session on the July 19th meeting. So that was not discussed, but I do feel confident that the information that was attached is public information.
All right.
I feel confident too.
Ms. Denny, please go ahead.
And I do want to bring up the comment that in July 19th, when it was discussed in closed session, this particular item was not agendized. However, we did talk about the substance of this particular case. So this is the first time this matter has been agendized.
Do you have anything further? I mean, is that the
sure.
substance of your request?
Yes, but I think Mr. Overham had a comment, or Mr. Wiley.
I will get to those people. I'm asking, did you want to explain your request any further than that?
Yes, I did.
Then please do. Sure.
So you've already read the title, and I want to explain to the public that this was this is a case of this is just a case gone haywire. And that, in fact, over 13 years and over $120,000 of taxpayers' money being spent on a case against one resident that has been unresolved to date is so horrendous, and I have zero tolerance for wasting taxpayers' money. And I think that, and this is exactly why I have recommended, and we are now receiving on council, regular reporting from our attorney to see how much public funds we are spending for legal and litigation costs. It's a matter I take very seriously. It's a very serious financial matter, and you cannot control costs unless you are on top of it and keep track of what they are. And we are now, as a council, receiving better. It's not perfect, but we're receiving better reporting from our contract provider for legal services because of my strong leadership in this regard, and I feel very, very, very strongly about that. We need to control costs, and I've made no secret of that. So the way to protect our future dollars is to make sure that nothing ever goes as haywire as this case again in the future. And so all I'm asking to do today, and I've asked the city attorney in 3 emails that are not printed in the agenda packet. They've been redacted or removed on advice of the third-party independent counsel. Basically, I asked 3 times for information and did not receive it, and then was spoken about as a non-agendized item in closed session on July 19th. And on those 3 occasions, I did not receive an answer to my question, which is exactly how much is paid for this entire case over the 13 years. I know it's $120,000, but there has to be more because we've gone on several months since the last bill. And I'm tired of blaming the defendants for large legal bills that the city, on cases that the city pursues. And so basically, what I'm looking for is just support from this council to direct staff to talk to the city attorney about refunding some of the legal bills. In fact, it's a practice done in many other towns in California and across the United States, and professional law firms, especially those which have such a long and close relationship as ours do, would seem to accept such a request for a refund with in an open and professional manner. And unfortunately, that didn't happen here. And specifically, the issue is 2 years ago on June 2009, in fact, the city won the case via a mechanism called default judgment against this particular defendant, who is a resident and a homeowner here in Coronado. And we have still been 2 years post winning the case, racking up legal bills on this case. And so I would like a refund. My initial request was for a refund of the monies in the past 2 years since the default, but since I have not gotten any cooperation from the city attorney, I would like now to go back and review the entire bill over the 13 years to see what can be refunded to the taxpayers of Coronado. So to me, this is a very serious issue. And I want to also just address a cryptic comment that was made earlier in this meeting by Carrie Downey, and I'm not sure if you were referring to me, and this agenda item is Downey, but you could not be more wrong and more untruthful by saying that my agenda item is politically motivated, if that is in fact what you meant by a cryptic message. It is purely 100% and totally a financially motivated agenda item. And I want money refunded to the taxpayers because they've paid far too long, far too much, and it's gone on far too long. And it hasn't even been resolved yet. And I yield the floor.
Is there a motion on this request?
I don't think that it needs a motion as much as it would just need a consensus to direct
I'm asking
staff.
if there is a motion. Is there one?
Sure, I'll make the motion.
For a second. There is not. So this item is concluded.
So the motion failed to get a refund of tax dollars for lack of a second.
Point of order.
Point of order.
I believe the motion has failed. Can we move on to the next agenda item, which is 11A, I believe?